Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, I answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Um, I just spent 15 minutes making this video, and then somebody came pounding on my door for a pizza party. It's Tuesday. Go do some work. Why are we having pizza in the office? We're not here for pizza. We're here for work. We're here to help our clients. Like this is why I work from home. I mean, it's one of the many reasons. Just ridiculous. Just ridiculous. Just who? All right. Um, so our video today. Somebody reached out to me and wanted help as a pro se litigant in structuring a counter offer in settlement negotiations. And I think that's probably one of the best videos we could make to help pro se litigants, if I'm being honest. So I thought it was a fantastic idea. But we do have to deal with one fundamental failing of the idea, in that I am not a pro se litigant. So all of the 14 or 15 years of settlement negotiations that I have engaged in this field, they're all going to be structured from the view of an attorney in this field, a plaintiff side attorney in this field specifically. So I will not have a full and complete ability to set myself in the shoes of a pro se litigant. And that's going to mean a couple different things. Because from what I can see, defense counsel hate communicating with pro se litigants. I understand that fundamentally. Listen, pro se litigants, you can see it on the channel sometimes, just start saying gibberish or get really mad and want to scream at the moon and I get it. They've been through a lot. And I also get it in terms of the gibberish because they're not people who work in this field. So it's not their job to know how things work or how the law is read or how like the case law is shaken out on a given topic or anything else, right? You'll get crazy legal theories. And the defense counsel's like, yeah, that's not even your case. You have a case, and I do want to settle the case with you. It's just that you don't even know what your case is. And so we're at a bit of an impasse, right? Like that's super common. Super common. Like it may be as common that a pro se litigant comes up with a theory that is not their case. Like their theory of the case is not even actionable, but they have a real claim that defense counsel is aware of. And defense counsel is trying to like get the case settled without tipping them off to their very real and potentially valuable claim. That happens all the time. All the time. So you got to keep in mind, whatever advice I'm giving you here is from my perspective as an attorney. And a lot of it's going to presuppose a couple of things. Like the defense attorney is going to want to speak with me. Even when they're mad at me, speak with me. They believe that they can go back and forth with me and they can disagree and argue and debate and I won't burn their house down or threaten their life or do a variety of things that they're actively afraid pro se litigants will do. You might chuckle at them. You might be like, oh, those wusses, those idiots. How could they think that? Because it happens. I assure you it happens. Like, I've been on the phone with people who are representing themselves who, like, want me to just draft some papers for them. And I'm like, yeah, I'm not going to do that. Like, we handle whole cases. We don't draft stuff for pro se litigants. That's not a good use of our time. And they'll just tell me what they're going to do to me. It happens kind of often. And you're like, okay, well, I guess you know where my office is, and I'm here. Big talker, let's see. You know? And that's all you can do. And I think that for defense counsel, often that can be unnerving. So they feel confident I won't do that because they've been working with me for a little over a decade now, and I guess decade and a half almost. But when they're talking to pro se litigants, they're afraid, they're uncomfortable. They don't know what you know. They don't know what you understand. They don't know where you're at emotionally. They don't know if you know to keep your blood sugar up during a negotiation. They don't know what your mental health is. They don't know if you're in pain. People in pain do wild things. So like they're just having conversations and trying to engage in a dollars and cents back and forth with the person who was horribly wronged on the basis of their identity. Right? I mean, that is dicey from their perspective. I don't begrudge them their concern at this situation. I get why they want you to have an attorney. And listen, I'm not going to be able to tell you how to get over some of those tensions inherent in that negotiation. I'm not. I've never done it. I don't know. I haven't had a lot of reps at it, right? I've had a lot of repetitions, a lot of reps at what I do. So I'm going to speak about what I do. And if you can extrapolate in a useful way from that, I really hope it helps. If you can't, then I guess you shan't, and it won't help you. And I'm sorry about that, but I tried my best. The second note I want to make about this video before we get into it is we're going to treat this video as if it lives in the real world, right? There's a couple of attorneys on YouTube who like to make videos about we're the $1 million settlement guys. This is how you make $1 million settlement. Ba, ba, da, ba, ba, ba. Yeah. I don't know how many of those guys have actually had $1 million settlements. I suspect perhaps not all. Perhaps not many. I don't know. I'm not going to say straight up because settlements are often not publicly available. So, I'm not going to say if they did or didn't. I'm just going to say that it's worth noting that they could go ahead and say they have a lot of experience with seven-figure settlements. But it's possible they don't. You'd have no way to verify that because during most of the period that those settlements would have taken place in most of the country, those settlements would have all been confidential. So there's really no one to call those folks out. Not looking at anybody in particular. Just saying, sometimes some attorneys say things to get clients. And listen, I've worked on seven-figure cases. Cases that had seven-figure results, certainly, without question. But that's probably not the best reason to choose an employment attorney. Like that. Those cases do require work and talent and skill and experience, sure, on the attorney's part. That's all required. But those cases were seven-figure cases, certainly before I worked on them, right? Those cases came in as they were. They had a valuation, and we were able to safeguard that valuation and get it over the line, the finish line, and get our clients paid, right? And that's great. But I don't know. It's not like I'm settlement Jesus over here, coming down from on high with the seven-figure lightning bolts. Is it Jesus or Zeus? I don't know. I'm not trying to make fun of your faith. I'm just saying, we're gonna keep this in numbers that might make more sense for the average pro se litigant, because the average case in this field is not worth seven figures, not even close. Just speaking statistically, right? I think like the average settlement in the EEOC is it might be like 40,000 or something like that, right? It doesn't mean that's what your case is worth. Every case is absolutely different, and certainly I think you might do better with an attorney. And many of those people who settled their case in the EEOC did so without an attorney. Keep that in mind. I'm just saying we're going to play with hypotheticals like $100,000 in most of this video, okay? It does not mean that your case is not worth seven figures. It very well could be. I'm not hazarding any opinion as to the valuation of any case in this video. I'm playing with hypothetical numbers meant purely for ease of math and ease of understanding. All right? All right. So let's get the lay of the land. In our field, the plaintiff leads with a demand about 99% of the time. There's going to be lots of pro se litigants who immediately say, I'm not going to do that. They come to me. Cool. They may not come to you. They may not, because there's a standard way of doing things in this industry, and a lot of defense attorneys will just tune out, and they don't really care, right? They're getting paid either way. They can fight you or not. If you won't talk settlement, they're not going to come begging hat in hand. They're going to bill the hell out of that case and make themselves some money. So just right off the bat, keep that in mind. So for you to receive a counter, you will probably have had to make an opening demand. For our purposes, we're going to assume that you made an opening demand of about $100,000. We're also going to name our defense attorney Steve. Steve is a hypothetical attorney who does not represent a real human being. But I'm using the name Steve because it's going to annoy the ever-living heck out of someone on the defense side. And, hey Steve, how's it going? And let's just say that Steve really hates negotiating with pro se litigants. A lot. Like, it might be the worst part of his career. And let's give a little context on Steve. I think it's important to know who you're negotiating with. Our hypothetical Steve recently made, like, junior partner at a defense firm. Makes, $450 to $550K a year. Does well. Has a couple divorces under his belt. He, lost a couple houses. Maybe he's a little angry at the world, but earns really well. And generally likes the earning potential of his field, although perhaps not the quality of life. And that's important to know. Like, keep that in your back pocket. Know that. That's context for the human being that you are wrestling with, right? And that's what you are. You're wrestling over a settlement figure in many ways. So you made your demand of $100,000. And Steve, the hypothetical defense attorney, comes back and says a couple different things. Maybe Steve says, I'll offer you $500. Maybe Steve says, well, I can't give you $100,000, but I'll give you $5,000. Or maybe Steve says, hey, I can't give you $100,000. However, I'm willing to start at $25,000. We have an array of potential things that Steve might have said. And we need to extrapolate meaning from all of those. Because we're engaged in a fact-finding stage. We are learning what our opponent is thinking. Okay? So, right off the bat, let's say you demand $100K and the defense counsel comes in at $500. You might choose to say, well, I'm not going to take $500, but I'll drop to $99,000 and $500. Well, now we need to look at the response from defense counsel Steve. Defense counsel Steve might come back and say, I just got an email. I got distracted. Defense counsel Steve might come back to you and say, yeah, I'm going to go to $501. I think we can extrapolate from that $501 offer that defense counsel Steve is telling you to go F yourself and that you're not going to get a serious settlement on this case. And that could be either because they don't think you have a real claim, or they don't think you can get your claim over the finish line, or they're just taking a no-pay stance for whatever reason. Or they just might hate you. Your employer might hate you. They might want to fight you to the end, even if it harms them in the long run, right? But you need to extrapolate from that 501, that 500 initial counter and the 501 second counter, that these people are not playing ball. This negotiation is probably dead unless you think you're taking something under $1,000. And our second hypothetical, defense counsel Steve came out and offered you $5,000. Well, you demanded $100,000 and Steve came back with $5,000. I think you can extrapolate that Steve thinks you are very, very wrong about the valuation of your case, or that you're not properly hedging for risk in your case, one or the other. And Steve is trying to signal that, hey, you're at 100, I'm never getting there, and I'm not going to meet you in the middle. Now, you might do some soul searching and decide that Steve is a little bit more right than Steve is wrong, or you might do some soul searching and you just say to yourself, no, I will embrace the risk of this trial. Let's go, right? But that's what Steve is signaling to some extent there. Probably. We don't live in Steve's mind. We're trying to guess, but we're guessing based on context clues. That third example, that's way more interesting. Steve comes back to your offer of your demand of $100,000, and Steve offers $25,000, but Steve says, "I'll start at $25,000." Yeah, Steve is forecasting that he is not trying to make you angry. He is not trying to insult you. He is not telling you to go F yourself. Steve wants to engage in a negotiation but cannot go too high because he knows you're a pro se litigant and he thinks that he's going to have to give himself some room to slowly negotiate up to end up at a figure that he can live with for his client. So there's a good chance if Steve comes to 25 as his opening counter, Steve is aiming for like 50, 60, 65, 70 in that range as a settlement figure. Now, you started at 100 in this hypothetical, just for ease of math again. And listen, somebody's immediately going to be like, you should start higher to give yourself more room to negotiate. Yeah, I mean, depending on the valuation of your case, yes, generally speaking, probably. That being said, you also can't go too high that it shuts down the negotiation. All right, so back to Steve. Steve is signaling to you, Steve wants to meet you somewhere in the middle. That's potentially positive. Now, you may or may not want to meet Steve in the middle. You may or may not. But you've now learned that Steve at least agrees with you a little bit about the valuation of your case and thinks that your case's merit and value and is more likely than not to recover at trial. Great. You've learned quite a bit. Our fact finding was very successful. Whatever Steve gives you, you have some ability to learn from. And you must increase your knowledge level of what is going on the other side whenever you have the opportunity. Now, you do have to do some soul searching here, right? Is your demand reasonable? Whatever the response from defense counsel Steve is, was your demand reasonable? If you demand $35 million and Steve comes back with $500, you can probably guess that Steve doesn't feel your demand of $35 million was reasonable. You don't have to agree with Steve. And I'll tell you right now, Steve could be wrong. Steve has every reason to try to trick you into believing that you're wrong. Do you have a $35 million case? It's possible. It's certainly possible. It's very unlikely, right? So why don't you pop out the damages calculation playlist that's on this channel and really crunch the numbers and get a feel like, hey, what's my case worth? And that's going to go a long way. And then you need to really think, well, okay, that's the valuation of my case. What kind of evidence do I have? What's in my favor here? What kind of risks do I run if I take this to trial? Can I take this to trial? I don't have counsel. I'm pro se. Can I try a case? I've never done that. I don't know how to do that. I've seen it on TV, but I realistically know that what happens on TV has no correlation to what happens to real life, so I have no knowledge about how this goes. And I don't even know how to go check out a trial so I can start to get a feel for how this goes, right? Okay, given the evidence I have and the valuation I've arrived at and the risks present, do I think my valuation at $35 million was reasonable? The answer could very well be no. Could very well be no. Now, if the answer is no, we need to back out of whatever harm we created with an unreasonable demand, because now defense counsel is at 500, and you're going to have to come down off your position of 35 million, and that doesn't feel great. But if you do want any chance of the case settling, you're going to have to engage in it, right? And I'm going to urge you to maybe be a little bit extra reasonable in the situation where you've opened with an unreasonable figure. And just recognize that you did something a little bit stupid. It hurts you a bit. And you're going to have to be a little bit extra reasonable in terms of your opening demand now, because you sounded like a moron in your opening bid. Okay? Happens to all of us. We all sound like morons sometimes. Don't take it personal. It just is what it is, right? And it's not your job to know how to do this. It's not your job. So it's okay. You've never had to do this before. No one should expect you to know how to do it. Perfectly fine. Now, you've learned some things. You've self-evaluated. And you need to answer this big question. If their offer was positional or symbolic, or if you know they were trying to aim for a particular result, a particular end zone for settlement, where do you think they're trying to end up? Right? I mean, there's where they're at today, and there's where they're trying to end up, right? We can pretty safely extrapolate from Steve number 3, who says, hey, I'm going to open at 25K, that Steve number 3, right, wants to pay more than 25K. How much more? We can also extrapolate from a fourth hypothetical Steve, who starts at 15K and says, hey, I'm going to open at 15K, but I got to tell you, we're not getting a 50. Right? That's a perfectly reasonable thing for Steve to say in this hypothetical. You might agree, you might disagree. You might say, there's no way I'm taking a settlement less than 50. That's your prerogative. Nobody says you have to. But you need to at least consider the possibility that Steve, hypothetical defense attorney Steve, is being serious when he says, yeah, I will start at 15, and I do have room to move, but I need you to know I'm not getting 50 grand. Could be true, could be a lie. You don't know. You're going to have to decide. Okay? All right, let's keep it moving. You got to digest everything. All your thoughts on the matter, everything you learned, you're internalizing it. You're living with it. And then start asking questions. That's what I would do. Steve, you're at 25, and that's not going to get it done, Steve. Talk me through. Why 25? What are we doing here? What are we doing? Why don't you see this case the way I see it, Steve? I think my client's got one hell of a claim. Clearly, you think my client has a claim. You're over here trying to write me a check. So why 25? And then shut up. Let Steve talk. Steve may not talk with you because you're pro se. Just realize it. Steve may not talk with you. Steve might just be like, that's the offer. It is what it is. But generally speaking, when you have attorneys talking to attorneys, Steve's going to try to give you some kind of argument as to why you should take 25. Or Steve's going to say something like, listen, we both know you're not going to take 25. That's why I phrased it the way I phrased it. But I need you to know we're not getting wild with this. There's a claim. It's got a value. We would love to pay you. We would love to pay you. But we're not getting wild. You're not getting any 90 grand here. All right? And again, these are all disappointing numbers. I'm not actually saying that any of these numbers are exciting for you in any way. I'm just keeping it in these brackets for two reasons. One, you're not, if you're watching this video, you're not represented. It's going to be very difficult for you to get six-figure settlements when you're not represented, in my opinion. Listen, prove me wrong. I'd be thrilled for you to prove me wrong. It's just my opinion. That's my belief. Two, it's just easy math, right? If we're playing around with 100 grand the whole time, it's super easy to bounce back and forth and kind of keep things a little bit consistent. So keep asking questions. Just be straight toddler about it. Like, 500? 500? With this fact pattern? I mean, how do you get around the retaliation component here, Steve? Come on, Steve. The evidentiary burden's on your client for retaliation, and you're telling me you're going to offer $500? $500? Steve, I got to know. I got to know why. Steve, you going through another divorce? Did she leave you, Steve? Like, why? Why are we doing this? What's going on? How did you arrive at X number? Right? Just ask everything. As long as Steve is talking, keep Steve talking and keep taking notes. And take all of it with a grain of salt. Don't believe Steve. Steve's there to lie to you. Steve's there to mislead you and to oppose you and to get you to take as little as possible. But Steve, as a human being, will convey information when Steve communicates. That's what human beings do, whether they intend to or not. And you may learn something incredibly important to your efforts here, and your efforts are all centered on raising the valuation of your case and getting a better settlement, right? Listen, if you have to ask why 30 times and Steve's still answering, I'm going to tell you to do it 30 more. As long as Steve is answering, two things are happening. Steve is billing, so Steve's happy, and you're learning things. Even when he lies to you, you might be able to learn interesting facts from what he lies about. Listen, I'm not above saying, listen, Steve, You keep telling me I'm going to lose at trial. How's that going to go? Can you just what do you imagine a jury's going to see here that's going to lose me this trial? What are the risks in your eyes? Help me present this to my client. What risks do you see? Because I don't see them, Steve. I don't see these risks. I think my client walks away with a payday 9 times out of 10 if we run this trial. And I give me your perspective. Let me see things your way, Steve. Can you tell me? Can you paint me a picture? And Steve might. Steve might. They do. You wouldn't believe it, but they do. And once Steve stops being responsive, we go into another digestion phase. We think. Steve right? Steve wrong? Is Steve full of shit? Steve's definitely full of shit. How full of shit? How much of what Steve said is just bullshit? Well, often most, but not all. Right? Which? That's a tough question. That's a tough one. But you're human and you've got some intuition. So you probably have some feelings about what was true and what was not true. The longer you do this, the more experience you have, the better that intuition will be. But it'll be as well informed as it can be, given that you're pro se. All right. The next phase is you might have a belief about where Steve wants to end up, right? Defense attorney Steve is trying to end up somewhere with this negotiation. What's your goal with your counter? Where are you trying to end up, right? You started hypothetically at 100,000. Steve countered, we'll go with the 25. Steve countered at 25K. Steve seems to be signaling 50, 60, 70K as the settlement number for Steve. Is that going to work for you? Is there a point in going further? Is it such that you would accept 70 but not 50? Well, that's really important. You got to structure your counter with an eye to achieving 70 then, not 50. A counter that lets Steve go to 50 and get dug in serves no purpose for you. There's no value. So what's your goal, right? Are you going to go out there and just be like, hey, this is my last best final? That's a strategy. Sometimes it works. It's very simplistic, but it can get things done. Are you going to make a counter that is an additional fact-finding fishing trip, right? Are you trying to learn more, right? So if you demand 100 and Steve goes to 25 and you drop to 25K to be clear, and you drop to 95, well, you're fishing a little bit because Steve might just match you, right? Steve might say, okay, if you drop to 95, I'll go to 30. Okay. Well, Steve is forecasting that it seems like you can all march down and meet in the middle there between 100 and 25. So you're getting pretty close. I mean, you could certainly achieve that 70 at that point, right? By the same token, Steve could come to 25K in response to your 100,000 demand, and you could drop to 95K, and Steve could say, I'm sorry, that's not enough of a move. I can't really counter you. It's just not realistic. Sounds like Steve is aiming for 50,000. Not to be confused with the Bard, 50 Cent. And you might not be able to live with that, but now you learned it. So you got to start thinking of, well, how do I get Steve to go higher than 50 when Steve is aiming for 50, right? Is there a way that I can walk them up to something that I would actually accept? And structure your plan, your strategy, your tactics to make it clear to Steve or manipulate Steve into getting to the number you could actually live with, right? And is that easy? No. Is it a science? No. No matter what that FBI negotiator guy might tell you, it's not a science. Not even close. You're feeling your way. Is that a line from a Grease song? You gotta feel your way, right? It's an art, not a science. And there's going to be a lot of intuition. And your intuition is not going to be well formulated in this field because you don't have a lot of repetitions, and that's okay. If you have to, get out your dowsing rod. Pray to your God. Whip out a Ouija board. Use the Force. I don't know. Do whatever you can. Like there's going to be some guesswork here, and you're trying to do as good and as right of a job as you can with that guesswork as you possibly can, as to what moves you can make that will nudge Steve to go higher. And that is a very unsatisfying response to how do you counter a settlement offer, right? But most of the art is going to be in the fact finding. And then in your mind and in your heart, you're going to formulate a response based on everything you've digested, all the fact finding you've learned. And you're going to come up with a plan that you think will nudge the human being on the other side to get closer to what you want. You're also going to have to live with the idea that maybe they won't. Maybe they won't come to something you would accept. And what do you do if they don't? Are you going to try a case? As a pro se litigant, maybe not. Maybe you will. I don't know. When you finally convey your demand, this is the next fact-finding phase. So let's say hypothetically, you led with your demand of 100K. Steve said, I'll start at 25, and let's say you drop to 90. You go from 100,000 to 90,000. You drop down. You're conveying a lot there. You're very clearly saying, listen, 50 is not going to do it. You got to go higher. Once you convey that counter, just stop. Don't be a Steve. Steve says, can you tell me why? Just say, that's where I'm at. And then open your listening ears. Get out your pad, your pen, and be ready. Because Steve's going to say some things. And those things can be really valuable for the next round of this negotiation, right? Steve might say, listen, you're not keeping a mitigation journal. I don't think you can get that high. Steve might say, listen, you don't have a mental health expert, or at least you haven't turned it over. So I don't think your emotional damages are going to get that high. I don't think you can get this much. I think you're being unreasonable. Okay. We just got two factors that maybe you can address, right? You can bolster those aspects of your case. Potentially. Maybe, maybe not. But you can certainly try, right? And you could certainly be successful. So we've just learned something very valuable. Steve might say, listen, I'm never going to get you more than 45K on this case. I'm never. Listen, I do a lot of these for this company. That's what they pay. Anything over 45K, they'll go to trial. You don't have to believe Steve. And I would urge you to not necessarily believe Steve. But it is possible that Steve is telling you the truth. So, it might be worth thinking on that one. Would I accept 45? I don't think I would. Okay, what's the counter? What's the other possibility? Trial? Well, it's still trial as a pro se litigant, which is why you're getting lowballed, because they're not worried about you running a trial. Can you do it? Maybe. Do you want to? Probably not. Maybe you do. I don't know. I don't know you, right? And that's really, like, this entire process, I would urge you to view as a fact-finding process. What can you learn? It's the same thing we say about mediation. Even if you don't want to settle your case, go to mediation. Learn. Learn the other side's position. Learn what the other side thinks about the case. Learn what the other side thinks are the faults and the problems and the risks in your case. Let them disclose whatever they're going to disclose. It all has value. And whether you settle the case or not, you might learn something very important in your case. You might be able to increase the valuation of your case based on what you learn and then go to trial with that increased valuation, right? The fact that you engage in settlement negotiation does not mean you had to settle the case. That's not how it works. Nobody can say yes but you, unless you're in the NLRB, in which case they can kind of say yes for you, but it's a different situation. We're talking about workplace sexual harassment, workplace discrimination. I hope this helps. I feel like it's going to be a very unsatisfying answer, because ultimately it comes down to you got to use a little bit of intuition and your listening skills. And that's hard and frustrating. If I asked somebody how to lower my blood pressure and their response was, you're going to have to use some intuition here, I can tell you right now, I'd be furious. That is not a useful answer. But it is the only answer. Truly. Listen, learn, digest information, extrapolate from responses. Try to create as clear a picture in your mind as you can of the totality of the circumstances. And use that picture in conjunction with where you want to end up to create a plan. How do we go from this picture to where I want to end? It's that simple. And by simple, I mean not simple at all. Anyways, listen, this is long. We're at 36 minutes here. If this was useful, like, subscribe, comment down below. Share the channel. It's how we grow. Comment down below. I'm sure you're going to have follow-up questions. I will try to make follow-up videos. Certainly, I think this is a very important video. I am stuck with the feeling that this may not have been as helpful as I had hoped it would be, now that I've delivered my little thoughts on the topic. But we can look at it as a first foray into this question and go from there. All right, take care, everyone.